Well, good afternoon and welcome to our ACC webinar. Sorry about that opening sting. I think our video froze on us just for a few seconds. But it's good to have you all online and joining us during your lunch hour. So thank you for taking the time to do that. My name is Heilala Tambete. I am the Business Development Manager at Corny and Lind, and a different voice to the usual Joe Swin, who's our IT tech guy and normally runs this. But look, as I've said, we've been providing these webinars to the ACC group, and so I'm quite happy to host you today. Before we start, just a couple of housekeeping things. If you do have problems hearing the webinar, I have placed in the chat box on the left-hand bottom side of your screen a phone number to call, a toll-free number. So our webinars are hosted by Redback Conferencing, and you can call that number 1-800-896-323 if you have difficulty in hearing. If the difficulty persists in terms of technical difficulties, there's a second number just under that, 1-800-733-416. For you to call the Redback Conferencing support team. They should be able to talk you through those technical difficulties and just have your participant code, if you were provided one, in your email handy to give to them. So today's webinar is titled Understanding Vilification and Discrimination, What Can and Can't Be Said from the Pulpit. What I do want to say is, if you'd like to enlarge the PowerPoint slides, just click and drag the page partition to the right. You will also have an opportunity to submit any written questions throughout the webinar. These questions will be viewable by all attendees. Again, you place them in the text bar on the left-hand side of the screen, just to ensure that we're not asking the same questions, but from previous practice, I think that our presenters will, and I've got a question here saying that it started but there is no audio. Can the rest of you hear me on this? Because I'm fairly certain. Are you able to hear me now? Oh, fantastic. Yep, that's great. Thank you for sending through your confirmations that you can hear us. I'm just going to ask if you were able to hear my housekeeping spill about the numbers at the top, just in case you have further difficulties. Just wait. Yep, thank you as well for that, Maria and Justin. I'll just increase all our audios. Fantastic. All right. So as I was saying, the topic is, again, understanding vilification and discrimination. I'm just going to briefly introduce to you the two who are presenting. We've got Natasha Duff, who's an associate here, and Michaela Warren, who are lawyers here. And they are both part of our litigation team. I know a couple of you might have been expecting Alistair McPherson, but as things do go, he's been called away to court for another one of our matters. So just a brief introduction. Natasha was admitted as a legal practitioner to the Supreme Court in 2012. Prior to joining Corny and Lind, she has worked for law firms in Brisbane and in California in the United States, primarily doing criminal and civil litigation work. Natasha is part of our Corny and Lind litigation team, focusing primarily on Australian employment and general compensation law. A A few of you might know her. She has cared for our larger institutional clients, including churches and schools, in a variety of litigation matters, which include discrimination and some sexual abuse claims. And Michaela Vaughan is one of our rising stars. She's a lawyer with our litigation team. She's done a Bachelor of International Studies and a Bachelor of Laws and Legal Practice from Flinders University in South Australia. She's currently pursuing a Master's in International Law at the University of Sydney. And she's also a member of our litigation team. She's previously worked in criminal law, compensation law, and corporate and commercial. And her experience stems from having worked with several NGOs, including the UN Working Group on Business and Human Rights, the Global Poverty Project, and Youth Affairs Australia, which relate to global justice and poverty. So, on that note, I'm going to hand over to Natasha to start the presentation. Thanks, Natasha.
Thanks, Haylala, for that introduction. I'll just start by quickly introducing our firm as well. I'm sure many of you are familiar with us, Corney & Lynn Lawyers. Over to the next slide. So we're a mid-sized firm with about 18 lawyers. And up there on the screen are our practice areas. Probably the most relevant for this audience is schools and education, not-for-profit and charity, and possibly the employment and discrimination as well. So shortly I'll be handing you over to Michaela, who's going to be talking about vilification and discrimination, but I'll be sticking around for the Q&A part of the presentation if any of you have questions. For those of you who haven't been to our offices, we are located right by the Royal Brisbane Women's Hospital here in Brisbane. So I'll pass you over to Michaela now to discuss vilification and discrimination.
Thank you for that, Natasha and Haylala, and thank you for joining us today. Today we'll be talking about vilification and discrimination, and I thought we'd commence with a short overview of discrimination, look at a case or two before moving on to vilification, because they are separate concepts and the implications for preaching from the pulpit are separate. Like Haylala said, please feel free to put any questions you want in the chat box. We'll address them at the end of the presentation, and hopefully you'll find today a useful and worthwhile enterprise, and you'll go home with a better understanding of what these areas of law are, and when you do need to seek legal advice about a potential issue. So, what is discrimination? The first thing to note with regards to discrimination is that it's highly jurisdictional based. So, coming up is just the primary, not all, of the relevant legislation around the country. As you can see, each state has its own relevant act. There are a few Commonwealth acts. That's not to mention the case law, as well as international law, which is actually the overlying basis of this whole area, the various international international law agreements. So it is highly jurisdictional based. And so if you do have a question, you will need to seek independent advice about that is relevant to your jurisdiction and to the situation that you're facing. So today, instead of giving any specific advice about it, we're hoping to give you more of an overview to help you identify potential issues and know when you need to seek some help. The basic outline of discrimination is that it is unlawful to discriminate in certain areas, for example, education, employment, accommodation, delivery of goods or services, on the basis of a protected trait or attribute. So the person who is alleging that they are discriminated against has to show that the action was taken because of their sex or gender, sexual orientation, race, religion, disability, age, marital status, pregnancy, political association, just to name a few. and that on that basis they have been treated less favourably than someone without that attribute. Now, this is what we call the comparator test, is this idea that you always have to compare the treatment of the person with the attribute with the treatment that would be provided someone without that attribute. And the basic idea is that it cannot be less favourable. There are two kinds of discrimination, direct or indirect. Direct discrimination is where one treats or proposes to treat the person with an attribute less favourably than someone who does not have that attribute. Let's go with a far-out example here. Let's imagine that a school decides to have a policy whereby no one with a physical disability, whereby they cannot walk, is permitted to attend their school. I can't imagine any instances where that would happen, but let's imagine this hypothetical school has this policy. That would be direct discrimination. That is saying that a person with a trait quite simply cannot access that good or service. Indirect discrimination, on the other hand, is where a condition is placed on access to a good or service that someone with the trait would be unable to meet. Again, going back to our hypothetical school, this would be, for instance, where the school, instead of directly saying we don't want anyone who has a physical disability that means they cannot walk at our school, they might put a condition on enrolment saying anyone who enrolls in our school must be able to play field soccer without assistance. Obviously, someone in a wheelchair or who requires crutches would be unable to meet that condition, and that would constitute indirect discrimination. I'm sure immediately you can start thinking of various instances yourself where this may or may not have come up in relation to you or someone you know, but the key question is always regarding the comparator. How do they treat someone with that attribute? How do you treat someone without the attribute? It should not be less favourable. That's just a basic understanding. There are, again, depending on the jurisdiction and depending on the area in which the discrimination is alleged, there are a lot of different defences, a lot of different conditions that need to be met. So again, this is just an overview. But what defences are particularly available to churches? I understand that today we're talking with churches from all over the country. And so you will be wanting to know, well, if I discriminate against someone in the basis of my church life, how is that applicable? One question that often gets asked to our firm is generally in relation to instances, for example, of same-sex marriage, providing services to same-sex couples, how to manage the transgender person who wishes to join the church, those sort of instances. It's worthwhile in such cases holding in your mind the Catholic Church, who has made a reputation for discriminating in employment on the basis of gender. They only allow men to be ordained, and that is not considered unlawful, and that is because of what is known as the religious sensitivities exemption. Again, this differs between jurisdiction and the area in which the discrimination is alleged, but it is something to hold in mind. And in Queensland, the exemption is found in Section 37 of the Sex Discrimination Act and the Section 109D of the Anti-Discrimination Act. Again, jurisdictionally based, this exemption, but it is one to be aware of. And it essentially, simplistically put, says that practices of a religious body that conform to the doctrines of the religion or are necessary to avoid injuring the religious sensibilities of adherents can receive an exemption from being considered discrimination. So the Catholic Church holds a doctrine that all ordained ministers must be male. and that failing to abide by that doctrine would potentially injure the religious sensibilities of adherents. Therefore, they are not held to have unlawfully discriminated against women on that basis. Now, this is only limitedly applicable to today, primarily because you will probably note that it focuses around religious bodies and as opposed to individuals. So a religious body must engage in the discriminating conduct as opposed to an individual. So there is not currently any case law making that addresses this, that seeks to apply it to an individual. So that's really at the moment, as far as I'm aware, based on the case law, it's a little bit up in the air. But it is worth holding in mind, and I just wanted to take you through one case that's particularly relevant, Christian Youth Camps Limited and Coble Community Health Services. Essentially, Christian Youth Camps Limited, it was a private entity that was managed by the Brethren movement. And an organisation contacted the campsite and asked to host a camp for suicide prevention for same-sex attracted peoples at the campsite. Now, the Brethren movement takes quite a conservative stance in relation to this issue, and they refused to allow this, and they were sued under the Victorian legislation. So this is a Victorian case, considering the Victorian legislation, but it is still applicable to many jurisdictions in Australia. The court in this case held that the Christian Youth Camps was not a religious body. So remember, we discussed that it has to be a religious body that engages in the discrimination. Christian Youth Camps was a separate entity, even though it was managed by the Brethren movement. And so it was not necessarily able to rely upon the exemption. Furthermore, the doctrine that was argued to apply was plenary inspiration, which is the concept that the Bible is divinely inspired and applicable and authoritative word for word. That does not necessarily, according to the court, include any particular stance regarding same-sex relationships. Plenary inspiration is a doctrine with regards to the validity of the Bible, not with regards to same-sex persons, same-sex attracted persons. And even so, the court found that the doctrine and belief structure of the Brethren did not require non-adherents to comply with its beliefs. So the Brethren's doctrines said, these are our doctrines, these are our beliefs, but non-adherents aren't compelled to comply by the same standards. And so that doctrine had an inherent contradiction within it when trying to apply it to this situation. Furthermore, it was shown that the proposed action would need to be an affront to the reasonable expectations of adherents to the Brethren religion. Well, Brethren is an offshoot of Christianity, a form of Christianity, but Brethren, people who adhere to the Brethren doctrines would have to be offended by allowing a same-sex camp, a camp for same-sex persons, to be held at the campsite. And it was found that the campsite was regularly used by secular persons, including those in same-sex relationships. And the campsite was not a church site. It was an independent campsite. And so it could not reasonably be held to be an affront to the sensibility of the adherents. Had they sought to have the camp at, a Brethren church, that might have been different. Had they had a regular policy of saying that anyone who uses the campsite has to abide by these particular doctrines. Potentially they might have been able to rely on it. Had Christian youth camps not been a separate entity to the Brethren movement, they might have been able to rely on the religious sensibilities exemption. None of those were the case, and so they were held to have unlawfully discriminated against Coburg Community Health Service Limited. So that's discrimination, broadly, basically, a little bit of an overview. What is vilification? Again, this is a separate legal concept that we're talking about now, and in Queensland law, again, jurisdictionally based. I apologise to anyone who's not in Queensland, but in Queensland you find the relevant law in the Anti-Discrimination Act, and it says that a person must not by a public act incite hatred towards, serious contempt for, or severe ridicule of a person or group of persons on the basis of race, religion, sexuality, or gender identity. So I'm sure you're immediately picking up there are a few different elements to this. Firstly, it must be a public act. How do we define that? We'll talk about that later. That public act must incite hatred, serious contempt, or severe ridicule of a person or group of persons. And that hatred, severe contempt, or severe ridicule must be on the basis of the race, religion, sexuality, or gender identity of the person or persons relevant. So that's actually quite a high bar if you think about it, for something that one says from the pulpit, which would conceivably be a public act, we'll get into that later, to incite hatred, serious contempt, or severe ridicule of someone else. And there are also within the legislation some definite exemptions. So the publication of a fair report of a public act, that would be if you are a journalist or if you are speaking about something that happened and that other act was an act of vilification, you are not yourself engaging in vilification. So a journalist who reports on a hate crime, they are not themselves engaging in vilification. The publication of material and circumstances in which the publication would be subject to a defence of absolute privilege in proceedings for defamation. We probably don't need to go into that in detail today. This is one that is potentially more relevant. A public act that is done reasonably and in good faith for academic, artistic, scientific or research purposes or other purposes in the public interest, including public discussion or debate about and expositions of any act or matter. So if you stand up and profess something reasonably, in good faith, and in the interests of engaging in genuine public discussion or debate, then that is potentially a defence that you can bring to an act of vilification. And this is the big one. This is the one that we get asked about quite a lot. What about my right to freedom of speech? Sure, it's fine to protect the right of these persons with these attributes, that's great, whatever, and I'm on board with that. But where does that impact my ability to profess my faith? Where does that impact my ability to say things that might not potentially be politically correct but are genuinely held beliefs by me? And that we will see is considered quite a lot by the courts. And in general, they've said, well actually, conclusively, they have effectively said, you have a right to freedom of speech, you do not have a right to vilify someone else. So vilification itself is not unconstitutional, the legislation out making vilification unlawful is not in itself unconstitutional and is not a contravention of your right to freedom of speech. But again, keep in mind what actually constitutes vilification. Inciting hatred, serious contempt or severe ridicule. Okay, so there is a line. There is a line to walk here between professing your beliefs and not letting that go into vilification. There is room for that. There is room for saying, I believe that Christianity is the truth, and persons who are Islamic are wrong, in effect, without that moving into trying to incite hatred and contempt and ridicule. And that's the key here. So what is a public act in Queensland? Any form of communication to the public, including speaking, writing, printing, displaying notices, broadcasting, telecasting, screening, or playing of tapes or other recorded material. And any conduct that is observable by the public, including actions, gestures, the wearing of, displaying of clothing, signs, flags, emblems, or insignia. Despite anything in subsection 1, which is that, a public act does not include the distribution or dissemination of any matter by a person to the public if the person does not know and could not be reasonably expected to know the content of the matter. So that's fairly all-encompassing. Anything by which information is disseminated to a large group of people is more than likely going to be considered a public act, and that includes preaching. Particularly if that preaching is then put up on the internet to your church website. So, what are instances where preaching or public acts that are based on a profession of the Christian faith have been accused of moving into vilification, of not towing that line appropriately? There is Menzies and another versus Owen. So Mr. Menzies was not a pastor, but he invoked Christianity. He was a shire councilman, and he published a report that was tabled in his council, which stated words to the effect of, fact or fiction, 73% of homosexual men surveyed had at some time had sex with boys 16 to 19 years or younger. Homosexual teachers are 90 to 100 times more likely to be involved sexually with pupils. Homosexual males are 500 times more likely to have AIDS. And that he believes this proves that you should not allow sodomites anywhere near schools, scouts, churches, governments or railways. In fact, I cannot think of anywhere on this planet I could recommend them to. So I'm sure that you are seeing there how this moves into vilification, okay? If he was engaging in genuine discussion, for example, regarding AIDS and the issue of the prevalence of AIDS within the homosexual male community, that would not be expressed in this way. It would be expressed in a way that said, okay, this proportion of homosexual males have AIDS, this is how much more likely they are to be infected with the disease. These are some public health measures we can implement that would be effective. This is an educational forum that we can run whereby homosexual males can learn about AIDS and how they can prevent it through the use of condoms, etc., etc. So that would be a genuine discussion for a public service, and that would potentially have come under the exemption that we talked about earlier. Instead, he then moves into, you should not allow sodomites anywhere. I cannot think of anywhere on this planet that they should be. And that then moves into hatred and ridicule and contempt. Mr. Menzies was sued, and the suit was successful despite several appeals. And throughout the proceedings, among other technical arguments, he did try to argue that Section 124(1)(a)(1) restricted his constitutional right to freedom of speech. The Queensland Court of Appeal held that Section 124A1 was not unconstitutional. And again, the court held that you have a right to freedom of speech. You do not have a right to vilify another person on the basis of the protected attributes. Another case was Catch the Fire Ministries Incorporated and Islamic Council of Victoria. This involved an AEG pastor who was preaching about Islam at a seminar for Christians, which was held on a YWAM base. I hope most of you are familiar with Youth with a Mission, YWAM. They're a mission organisation that do a lot of good in the developing world and a very prolific and effective ministering and evangelistic organisation. That pastor was preaching about Islam and the need to evangelise to the Islamic community, and he and his ministry were sued under the Victorian legislation. So this is a Victorian case. They lost and appealed, and the court upheld the appeal. The court ruled that what is said in a religious seminar by a true believer of one religious faith concerning the perceived inadequacies of the tenets of another might be regarded as bona fide and reasonable for a genuine religious purpose of witnessing to the adherents of the other persuasion. Okay? So it is okay, it is not vilification to, in your small group, say, these are the concerns that I have about Islam and the Islamic faith and the issues within the Islamic world. These are some ways that I've heard are really good to talk with persons of the Islamic faith about Christianity and ways that we can meet and hopefully bring them to Christ. That is not vilification. Interestingly, the court also determined, as it did in Owen and Menzies, that the relevant section of the Victorian legislation was not constitutionally invalid. So you have a right to freedom of speech, not to vilification. And this is the relevant Victorian legislation that the case was brought under. The last case I wanted to discuss was Three Wise Monkeys and Durston. Mr. Durston published a pamphlet called Three Wise Monkeys, in which it was conveyed that homosexuality should not be tolerated. Gay people were more likely to die of disease and in traffic accidents than heterosexuals. Scripture rejected homosexuality as abominable. Gay people died on average in their 40s. Lesbians are 435 times more likely to be the victims of murder, 932 times more likely to die from suicide, and 466 times more likely to die in traffic accidents. Where he got those statistics and the relevance of them, I'm not entirely certain. However, he was sued under the Tasmanian legislation for vilification. The court found that the word incite should be given its ordinary and plain meaning: to urge, spur on, animate, stimulate, or prompt to action. So stating a fact, not sufficient. There should be some kind of call to action. The court also found that it is not necessary to prove that the publisher intended the publication to incite persons to hatred, serious contempt, or severe ridicule. The test is whether the public act is capable of such incitement. The public act must be capable of inciting intense dislike or hostility, and the conduct must be capable of arousing reactions at the extreme end of that scale. So not a little bit of, oh, I'm not sure. It must be extreme, intense hostility. Okay, so that's the extreme end of the scale that we're looking at here. And the aspect of the conduct complained of must be assessed within the context of the entire statement or publication. So the publication as a whole must give this call to action, this call to have hostility, severe contempt, and ridicule for persons on the basis of the protected attribute. And finally, the proper approach is how an ordinary, reasonable person would respond to the publication. So you have to say that This is a test that we use a lot in law, and you end up hating by the end of law school. But what would the reasonable person do when they read the entire publication? Okay? And that is what the court has to decide. So those are some cases. That's a basic outline of the law with regards to discrimination and vilification. Again, highly jurisdictional, highly situational. So if you have concerns, you need to seek independent advice on it that's tailored to your situation. But basic take-homes. Respect is key in preaching, in expression, in sharing with others. It's actually okay to express your faith as long as that then does not move into hatred, severe ridicule, contempt, those things that we discussed. If it's a respectful conversation where you say, this is actually my belief, that's perfectly fine. You can live according to your beliefs as long as this does not harm others, encourage others to harm others, or lead to you discriminating against someone on the basis of a protected attribute. So you can actually still live your faith, which is good news. Don't do. And do not treat someone less favourably because of their protected attribute. Do not engage in behaviour that harms others, particularly on the basis of a protected attribute. Publish, preach, do not publish, preach, act, or otherwise engage in behaviour that encourages others to harm, hate, have severe ridicule or severe contempt for others, particularly on the basis of a protected attribute. So I hope that has given you a better understanding of the legal framework that you're looking at, and that you're hopefully more comfortable with what you can and can't say from the pulpit. It is still okay to be a Christian and to profess the Christian faith within limits. It's still okay to preach and to say, this is what I believe. Now it's time for questions. So Natasha and I are here to answer any questions that you may have on the basis of this talk, and we look forward to hearing from you.
Yeah, thanks for that, Michaela. What we might do is I'm just going to put us on silent and give about 2 minutes if anybody has any pressing questions to ask in relation to the presentation. And then as we receive the questions, we'll come back online to see whether we can answer them. All right, thanks everyone. Thanks, Murray. We did have a very brief summary on what a protected attribute is. The question is, we may have missed something at the beginning, but what is meant by a protected attribute? Natasha, Michaela? Protected attribute is in relation to discrimination. So,
thank you for that question, Murray. A protected attribute, as Helala touched on, is primarily in relation to discrimination, and that is an attribute that's protected by legislation, and an attribute on which it is unlawful to discriminate on that basis. So this includes sex or gender, sexual orientation, race, religion, disability, age, marital status, pregnancy, association, political association. So those are just some of the traits that are protected by legislation that then mean that you are not lawfully able to treat them less favourably than someone without that attribute.
Yeah, so Murray, just to go back on that, that is actually on a page within the presentation, and a copy of this presentation as well as a copy of the recording will be made available to those who are listening in probably within 24 to 48 hours. I think our usual process is the ACC does notify you when we have it live on our site. We've got another question here from Joshua So you can say whatever you want about Islam as long as you are asking people to love Muslims. Whoa, and that's another very long question. I'll ask Natasha to address that before we move on to the next question.
Thanks for your question there, Joshua. Just on that, look, we wouldn't recommend that you say whatever you want about Islam. Obviously, that's quite a broad spectrum. In terms of the application of laws regarding vilification, you still need to be ensuring that whatever it is you say, even if at the end of it you say, make sure you love Muslims, is not inspiring extreme hatred towards them. So I wouldn't say that you can say anything you want about Islam, just so long as you ask people to love Muslims at the end. I'd certainly make sure that you're not encouraging negative behaviour towards Islamic community members, or not inciting anything on that extreme end of the spectrum where people are going to want to exercise or act out on hatred towards the Islamic community.
I think another thing to add as well, which Michaela also touched on, was that you have to be mindful that it has to be within a public setting. So your words, your publication has to reach a large amount of people. And then once that test is fulfilled, where it reaches a large amount of people, it then comes down to the content of what your words and whether they incite or spur on those who hear them to act out as a result of. Okay, we'll just have a look at the next question from Linda, which is, so it's permissible legally to preach, example from Romans 1, where it says, because of this, God gave them over to shameful lusts, even though women exchanged natural sexual relations for unnatural ones. In the same way, sorry, I'm just having a bit of difficulty flicking this. In the same way, the men also abandoned natural relations with women and were inflamed with lust for one another. Men committed shameful acts with other men and received in themselves the due penalty for their error. Right. All right, I'll just hand over for a sec to one of our presenters.
Thanks for that question, Linda. It is legal to preach from any part of the Bible. That is, there is nothing preventing you from preaching from any particular verse. What you have to be mindful of is, in preaching from that verse, do your words then incite hatred, severe contempt, or ridicule of persons based on their sexuality, if you're preaching from this particular passage? So by all means, preach from it. Just ensure that when you do, you are not inciting hatred, ridicule, or contempt.
Right. And there's another question as well from, how often are people of other faith charged with vilification laws?
Yes, thanks, Joshua. That's actually a really good question, and I have to admit that I believe that they have been. I do recall seeing a case or two on this, but I can't cite them off the top of my head, so I can't tell you how often they have been have faced allegations of vilification. But if you were very interested to find out, these cases are public record. So I'm sure if you were interested in legal research and had a day or two at your disposal, you could go through the different jurisdictions and the different courts and find that out for yourself. that would actually be an interesting exercise. I might do that.
Oh, thanks for that. Okay. Whilst we're waiting for the next question, I can see someone typing. Oh, thank you, Lainey. Thank you for thanking us for the informative session. That's the contact details for the two who've presented today. And on the next slide is when the next ACC webinar will be held. The topic is the difference in governance and management, going beyond reproach and increasing meeting efficiencies. And as I said earlier, we will make a copy of the recording and this presentation available to the ACC probably 1 to 2 days from now. Please note that the webinars are password protected. I have stuck that in at the bottom of this slide, and you should be able to access it even now. What we actually might end this webinar, but what I'm going to do, because I can just see another question come through, I am going to save that question. Andrew, would you mind sending through your email address? And if you do have any other questions, I am putting in right now the address for you to send it to. And what we can do is we can take this conversation offline in order to be able to answer it with a bit more time. So, yep, thank you. I've received that. Heritage Church, we'll discuss it and we will get back to you. All right, so without any other further questions, thank you everyone. Thank you for giving us your time today. We look forward to serving you at the next webinar. It is an interesting topic. It's still one that has legal ramifications that we're trying to get our head around. So we will come back to you offline on this. Have a blessed day, and we'll speak to you next. Thank you. Bye-bye.